Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about private prosecutions. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Klippenstein started a private prosecution, and before his case could get to court and before he could argue that the violations of various statutes that he was alleging had occurred, the Attorney General intervened and stayed the private prosecution. This is surprisingly common in private prosecutions. Although the Crown is responsible for bringing prosecutions against individuals in Canada, there is a process by which private individuals can commence an action against other individuals for a violation of the law. But there's a rule that allows the Attorney General to just jump on in and stay the charges without any other involvement in the case. And that's exactly what happened here. The problem is that there's a good public purpose reason for having private prosecutions. It may not always be easily apparent to the Crown why a prosecution is necessarily important or in the public interest. It may not be apparent to the Crown why a prosecution is not destined to fail. And to give the Attorney General, the Crown, the right to end a private prosecution at any point at will essentially eliminates the real ability of Canadians to bring private prosecutions. They are nevertheless difficult to succeed in. They are very rare in Canadian law. And putting some rules on the Attorney General's ability to just end these private prosecutions wouldn't lead to a floodgate of litigation. And if it did, the notion of those rules could clearly be revisited. The Supreme Court of Canada, in this case, had an opportunity to sort of roll back the power of the Attorney General to stay a private prosecution and to allow these to be a real thing that could potentially succeed from time to time against individuals who may very well be deserving of prosecution for various statutory violations. Unfortunately, the Supreme Court of Canada didn't see the merit in taking that approach in this case, which means that there are going to be numerous other private prosecutions, expenses incurred by people attempting to bring those, stayed by attorneys general throughout this country before we see a case where there is some good reason seen by the Supreme Court of Canada to impose some limits or considering imposing some limits on the private prosecutions. Until we get to that point, unfortunately, this is the reality for private prosecutions in Canada. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.